Welcome to the Lawyers Society Legal Podcast. In this video, we'll be talking about one of the paragraphs that is being included in every bail or anticipatory bail order that is being passed in the state of Tamil Nadu. But before proceeding into this video, if you are listening to this on Spotify, please do follow us. And if you are listening to this on YouTube, do subscribe to our channel and click on the bell icon for more interesting legal discussions. Now coming back to the topic. If you read any bail or anticipatory bail order in the state of Tamil Nadu passed by a High Court or a Sessions Court, you will find this particular paragraph which reads, on breach of any of the aforesaid conditions, the learned magistrate or trial court is entitled to take appropriate action against the petitioners in accordance with law as if the conditions have been imposed and the petitioner is released on bail by the learned magistrate or trial court himself, as laid down by the Honorable Supreme Court in P.K. Shaji vs. State of Kerala, reported in 2005 AIR SCW 5560. What this basically means is that the High Court or the Sessions Court, while granting bail, is delegating or granting power to the magistrate to cancel bail when the bail is being granted by the High Court or the Sessions Court. Now let us first look at what the judgment in PK Shaji vs. State of Kerala held. As we know, the judgment in PK Shaji was rendered on 27/10/2005, so it's a very old judgment. In this case, the issue was whether the Sessions Court, while granting bail, can include a paragraph directing the magistrate to cancel bail in case the magistrate receives any report from the police that the person who is on bail has not complied with any of the conditions. When this particular paragraph was challenged before the Honorable Supreme Court, it was said that the High Court or the Sessions Court has the power to direct the magistrate to cancel the bail in case any condition is breached. So basically, when you read section 439 subsection 2 of CRPC, you find that the High Court or the Sessions Court always has the power to cancel bail. But there is no specific provision which grants the magistrate with the power to cancel bail, be it bail granted by the magistrate himself or bail granted by the Sessions or the High Court. But since the PK Shaji judgment was rendered, we find the reference to PK Shaji in every bail order that is being passed by the Sessions Courts or the High Courts in the state of Tamil Nadu. But what is the history of this particular template? For this, we can actually do a very short research and the result is very interesting. The very first time this particular paragraph was being included in High Court bail orders can be traced to the case of Manoj vs. State of Kerala, where Honorable Justice Thomas P. Joseph from the Kerala High Court used this paragraph in a bail order. This is from the April month of 2012. But after this, you can find that for a matter of 3 or 4 years, until 2015 or 2016, Honorable Justice Thomas P. Joseph in about 400 to 500 reported matters has used the same template. But until 2015, it was only Honorable Justice Thomas P. Joseph from the Kerala High Court who was using this template across India. So no other High Court was using PK Shaji in its bail orders until then. Then there is one case from the Himachal Pradesh High Court where Honorable Justice Tarlok Singh Chauhan used the particular template in the case of Chaman Mehta vs. State of Himachal Pradesh, which was rendered in the July month of 2015. The next High Court which adopted this particular paragraph in its bail orders is the Madras High Court. Now this is when Madras High Court first started using this particular template, and the order was passed by Honorable Justice P.N. Prakash, who is now retired. And the first case that I could trace and find from the journals is G.K. Tepaswaran vs. Naseem Banu, which was decided around the end of 2015. Now the interesting fact here is that Honorable Justice P.N. Prakash was a special public prosecutor in NDPS Act cases in the High Courts of Kerala, Tamil Nadu and Andhra Pradesh. But I think he was only in that position up until 2005 or 6. But I think he was aware of Kerala High Court bail orders, or he might have read some of the orders from which he acquired this knowledge or the possibility of including PK Shaji in the bail orders. So from there, I think it just entered the Madras High Court, and from then you can find that almost every judge who has ever handled bail matters in the Madras High Court, both the principal bench and also the Madurai bench, they have rendered bail orders by using the same template. And the template has gone to the sessions courts, and now all the sessions courts also use the same template. And the other interesting fact that I found is that Honorable Justice M.V. Muralidharan, who was transferred from the Madras High Court to the Manipur High Court, also took the particular template from here to the Manipur High Court, which can be seen in one reported case that Honorable Justice M.V. Muralidharan handled in the Manipur High Court. The case title being Ningol Karam Ongpi Romita Devi was a state of Manipur, which was decided in the year 2019. Now you can ask me, is there any other high court which has ever used this particular template? There is one order I found which is from the Andhra Pradesh High Court, which was decided by Honorable Justice K. Manmadha Rao. The case cause title is Sayani Srinivasa Rao, was a state of Andhra Pradesh. It is from the year 2022. So these are the high courts which have used this template, but the only high court which is to use it till date is the Madras High Court and all the district courts in the state of Tamil Nadu. Now when I say the Madras High Court is the only high court to follow this template right now, it is because the Kerala High Court stopped using this template in the year 2019. And if you see in the journals, as per the journals, it is found that there are only 3 judges ever from the Kerala High Court who have used this template. One is obviously Justice Thomas P. Joseph from the year 2012, and he used it until the year of 2015. And then you can find one order from Honorable Justice Raja Vijay Raghavan from the year 2016. I couldn't find any other reported cases from this particular Honorable Justice, but later you can find more than 300 to 400 reported judgments from Honorable Justice Sudhindra Kumar, who from the year 2015 has been using this template. But all this ended in the year 2019. So the Kerala High Court used this template from the year 2012 to the year 2019. But the Madras High Court picked up the trend from the Kerala High Court in the year 2015. And the same has been going on forever. So it is a very interesting find, because for any person who reads bail orders here, the compulsory paragraph is the P.K. Shaji paragraph, and any curious person will be eager to know the history of this particular trend. And I think this is the comprehensive history, and only 4 or 5 high courts in total have used this particular paragraph. And there is only one instance I could find from the Himachal Pradesh, the Manipur and the Andhra Pradesh High Court, but there are a lot of judgments from the Kerala High Court, but they end in 2019. The Madras High Court and the Sessions Court in the state of Tamil Nadu are continuously using the same template. It is an interesting addition to bail orders because it clarifies the fact that the magistrate has the power to cancel the bail instead of allowing every case to come to the High Court or the Sessions Court unnecessarily. So delegating the power to the magistrate is a good way to ensure that the police has an immediate remedy of approaching the jurisdictional magistrate to cancel the bail and secure the custody of the accused. What are the other paragraphs you think can be added to bail orders? And what other history or what other judicial trends you want me to trace? You can also try to find the first quash petition that was filed before a high court under section 482 of the code. It would be very interesting to see which high court first quashed any order, or which advocates first understood quash petitions and the possibility of quashing a criminal proceeding. There must be a first instance always, as in this case the Kerala High Court was the first to use this template. There will be a first instance for every petition out there. So that will be very interesting to search, to research, to find, come up with another video and explain to you guys. If you found this video interesting and you want more of these, do subscribe to Lawyer Society and keep following us on YouTube and Spotify. Thank you.